everyone, I'm Ellen McCloskey, and today we're going to be talking about FERPA and student data. So what is FERPA? According to Rosenberg 2014, it's the Family Educational Rights and Privacy Act, and it's a federal law that protects the confidentiality of student education records, and it applies to all schools that receive federal funding for any sort of program. And it's administered by the Family Policy Compliance Office, so the FPCO, that's directed by the Department of Education. Why is it necessary? Information is collected on students as soon as they enter in preschool throughout their entire time in school. And so there's a large amount of information that's collected within schools and through third-party vendors that schools work with. And in recent days, there's been various ransomware attacks in a short period of time, which is malware that's designed to deny a user or organization access files on their computer. So it detects the computer, and then anyone has access to all of that student information that has been collected. And then kind of another concerning piece behind FERPA here is that districts across the nation do not have strong student data protection. And the State Student Privacy Report Card, released earlier this year by the Parent Coalition for Student Privacy and the Network for Public Education, gives no state the top grade, an A+, for their laws protecting students' data. The top scoring state was Colorado, who earned a B. What does FERPA cover? FERPA covers, according to the Privacy Rights Clearinghouse, that parents can inspect and receive a copy of student records. They can deny access to others. They can process to correct error. There's a process for them to correct errors within the file. They can opt out of military recruitment for their child. They can opt out of the disclosure of a student's directory information. And then there's also a complaint process that's built in for them. And so an important piece to note here is that FERPA applies to parents, adult students age 18 and over, or who are attending a post-secondary institution, or parents who claim children as dependents on their taxes retain these rights. And education records can be anything directly related to a student that has personal identifying information on it that's maintained by the school or that third-party vendor on behalf of the school. So some sample examples of education record information, according to Rosenberg 2014, are student grades, immunization and health records, disciplinary records, student progress reports, academic or physical testing results, grade point average, attendance records. Some of the things that are not included in education records are any sort of teacher notes that are used for memory aid throughout class, law enforcement or campus security records for law enforcement purposes, employment records, alumni records, grades on peer-graded papers before they're recorded. What does FERPA not cover? It doesn't cover parents suing the school. Parents must respond to opting out opportunities, so that kind of limits them a little bit. And it does not dictate requirements for safeguarding education records. So it doesn't tell schools how these education records should be stored. It doesn't tell schools how they should be destroyed. And so there's no sort of safeguarding requirements within FERPA. Law enforcement unit education records are not covered under FERPA, so those do not have to be released. And then if there's a health or safety emergency, a lot of times these student education records can be handed over without written consent from the parent. FERPA and school recordings or images. As security cameras have started to increase in a lot of high schools and just schools across the nation, as they're in more than 94% of high schools, it kind of leads admin to be at a bit of a bind legally. And so Fox and Solomon 2019 takes a look at the Fourth Amendment, which prohibits governmental entities such as public schools from conducting unreasonable searches. Courts have considered whether surveillance recordings violate the Fourth Amendment, have scrutinized the scope and manner of the recording. And so courts have generally upheld that video recordings in school hallways, stairwells, school buses, school parking lots, and even classrooms, so kind of those public areas, are able to be released for this purpose. And the district should really be careful and should make sure that they have policies addressing these images. And when we're looking at state wiretapping laws, districts should consider audio surveillance where they may attempt to mitigate risk by posting conspicuous signage to notify individuals that conversations may be recorded. So again, it goes back to that idea of making sure that there's policies in place. And then it always comes back to the question of whether a recording is directly related to a student or not. And so we want to look at 4 key factors. So we want to look at whether the recording is used for disciplinary action involving the student, whether the recording depicts an activity that would reasonably result in the use of disciplinary action, shows a student violating the law, or shows a student getting injured, attacked, victimized, or having a health emergency, whether the school intends to make a specific student the focus of the recording, and whether the content contains personally identifiable information from a student's education record. And then law enforcement access to surveillance recordings, and then third-party access to recordings. So there's different laws that guide these as well, and it all just kind of depends on whether it's directly related to a student or not for it being released. FERPA and the Department of Education. FERPA has been a confusing law that has not changed with the ever-changing classroom, and so it's kind of gone back and forth and hasn't provided as much guidance as it truly should, and it really hasn't. It was created in 1974, so it hasn't really kept up with the digital age of the classrooms. And according to Cunningham 2019, more than 120 privacy laws in at least 20 states have been passed since 2013, creating a confusing patchwork of statutes. And historically, FERPA complaints have taken a large amount of time to be addressed. And truly, it should be something that is operating effectively and efficiently to enable the resolution of complaints as quickly as possible. But what's kind of happened in the past is that these complaints come in and they take so long to address that either it's no longer a concern to the parents anymore, or the student has already left the school through graduation, and so then it's just a moot point. And kind of one of the other pieces just to keep in mind on here is schools should always be thinking about why are we holding this information, how long should we hold it, and who are we allowing access to the information, because that kind of ties in line for how to stay compliant. Because we want to make sure that we're creating policies that address the keeping and destroying of data. FERPA is really silent on the housing of data and also the destruction of data, but we want to make sure that we create those policies for keeping and destroying data. And we want to ensure that the vendors that we work with have FERPA safeguards in place. And so iCite No Date states some ways to stay compliant are to raise FERPA awareness, confirm that FERPA applies to you, know the rights, protections, and exceptions, choose compliant vendors, train all school employees, implement compliant policies and procedures, encrypt files and emails, and implement other prevention tools. So we want to make sure that we also shred student records, screen vendors' data, and making sure that we make it clear that data is belonging to the school and not to the vendor. Parents also own the FERPA rights or the 18-year-old child. And so when we look at FERPA as a part of IDEA, depending on the type of data involved and the context in which the data are being used, there may be a specific requirement with which educational agencies and institutions must comply. For example, Part B of IDEA requires public agencies to inform a student's parents when any personal identifiable information is collected, maintained, or used thereunder is no longer needed to provide educational services to the student. So if we no longer need that information, then those records should be destroyed. And IDEA defines the term destruction as the physical destruction or removable of PII from information, so the information is no longer personally identifiable. And then these are the references that I used throughout the presentation. Thank you.